Welcome everyone to our webinar on unfair contract terms, a legal update for in-house counsel. My name is Stephen Drysdale. I'm a senior lawyer in our contract and regulatory team at LegalVision. I'm joined today by my co-host Tim, who's also a contract and regulatory lawyer at LegalVision. Before we begin, a couple of quick housekeeping items. Today you'll receive a recording and a copy of the slides in your email at the end of the webinar. If you have any questions, please submit them using the Q&A function in the Zoom taskbar. We've also had a high number of pre-submitted questions that we're hopefully going to try and get through a good chunk of them at the end of the session. And at the end of the session, there'll be an opportunity to complete a feedback survey. I really recommend that you do that as well. Mostly because you can book a call in with our enterprise team to just learn and discuss about how we can support maybe your in-house team's workload or maybe other legal needs for your business. So you can do that by leaving your contact details in that survey. So today we'll be discussing unfair contract terms, and we'll be going to run through sort of a list of these items set out in the agenda. So I'm going to start by sort of explaining at a high level what unfair contract terms are and how sort of a court or the Australian Competition and Consumer Commission will assess whether something is an unfair contract term. Tim's going to walk us through what applicable contracts the regime applies to. And then we're going to talk through some examples of unfair contract terms that we've seen, talk about the federal court case against Fujifilm, recommend some practical tips in terms of unfair contract terms and how to avoid them. And then lastly, talking about what the consequences of having unfair contract terms in your contracts actually mean, followed by the Q&A session. So I'll kick us off with what are UCTs, or unfair contract terms. Now, these are imbalanced terms causing detriment at a very high level, and they're sort of a three-tiered test for determining whether something is unfair. So first, we need to look at whether there's a significant imbalance. In other words, is it very one-sided? Is it weighted against a party? Is there sort of this shift in power that maybe, doesn't make sense, or just generally there's some sort of, imbalance. So things like, if a party has a right to do something they cannot another, or it's preventing someone from doing something that the other party can do, that's likely to be a significant imbalance. The second question is whether it's actually reasonably necessary to protect a legitimate business interest. And this is sort of, I guess, the defense for the business that's trying to rely on a potentially unfair term. So when we look at a legitimate interest, it's things like, are we trying to recover maybe a particular cost or expense rather than simply, discouraging termination or some sort of penalty? And then lastly, that third limit is, does the term actually cause or is likely to cause detriment, usually in the form of financial harm to the other party if it were enforced or relied upon? So that's sort of the three-stage test. Is there an imbalance? Is it reasonably necessary? And will it likely cause detriment? So why the focus on unfair contract terms? There's been significant law changes in the last or in the end of last year, increasing the scope of the regime. So redefining, what type of contracts the unfair contract term regime applies to, and also introducing and increasing new penalties for non-compliance. There's also an increased activity from the ACCC in terms of enforcement. So the ACCC action against Fujifilm, which we'll talk about in further detail, is the big one. And also it's a priority for the ACCC's 2024 to 2025, I guess, enforcement priorities list is really cracking down on non-compliance and the use of unfair contract terms in consumer and small business contracts. I'll pass to Tim now. He's going to speak about the types of contracts that the regime applies to and walk you through sort of the ins and outs on that front there.
Thanks, Stephen. The next question is, to what contracts do UCTs apply? So UCTs, or unfair contract terms, apply to standard form consumer contracts for the supply of goods or services or the sale or lease of land. So what is a standard form contract? Factors for a standard form contract include whether the other side was given an opportunity to negotiate the agreement, whether they were able to obtain independent legal advice, even if they ultimately did not obtain such advice, and whether your business or one of the parties to the contract engaged in good faith negotiations of the contract. With this in mind, if your business does engage in good faith negotiations, but ultimately pushes back on lots of areas and only really entertains minor changes, then the contract will still likely be considered a standard form contract. The next question is, who is the other party are they a small business or an individual? So if they are an individual and they are a consumer entering into the agreement wholly or predominantly for personal, domestic, or household consumption, the regime will apply. And if they are a small business, then the regime will apply. So this means a business that employs less than 100 people or has an annual turnover of less than $10 million. So this will apply to, a lot of businesses within Australia, particularly within the SME space. So if the regime does apply to the contract, it means that your business will not be able to enforce or rely upon terms that are overly unfair and not supported by a legitimate business interest. And just one final thing to note, the new regime applies only to standard form contracts made or renewed on or after the 9th of November 2023, or terms of a contract varied or added on or after the 9th of November 2023. So a couple key updates that have come in to the UCT space recently is within contractor agreements and a recent case as well regarding international contracts. So firstly, regarding contractor agreements, the Closing Loopholes Bill has introduced to update the Fair Work Act, and it provides a new ability for the Fair Work Commission to make orders in relation to unfair contract terms in independent contractor agreements. The Commission can only make an order where it is satisfied that the contract contains one or more unfair contract terms, which in an employment relationship would relate to workplace relations matters. So these are things like remuneration, leave entitlements, hours of work, and the ability to terminate the contract as well. The Commission must take into account pretty similar considerations to those set out in the ACL, and where a term is considered unfair by the Commission, they may make an order to have the term set aside or be varied, but ultimately there's no financial penalty or compensation unless, of course, the order is contravened. And one final thing regarding contractor agreements, it will not apply to contractors earning above the high income threshold, as they're not able to bring a claim in the Fair Work Commission. But that's specifically within the Fair Work space. So they may still have options to bring a claim under the Australian consumer law. The next one is international contracts. So there was a case regarding Ruby Princess Cruises in the High Court, which essentially confirmed the extraterritorial operation or global reach of Australian consumer law. As a quick summary, it was a 2023 claim that was made by a Canadian citizen following a COVID outbreak aboard the Ruby Princess cruise ship, which is operated by Carnival, and they're incorporated in Bermuda, and the individual was accepting the US terms and conditions. Ultimately, the court found after various appeals that the terms included a class action waiver, denying the customers the ability to bring a class action, and this was ultimately deemed unfair and void. So the main takeaway from this is that the UCT regime will apply to all entities carrying on a business in Australia. So it's something to keep in mind, even where you are entering into contracts where potentially it's governed by a foreign law and it's with foreign entities, as even a tenuous connection may apply. I'll pass it over to Stephen now to discuss some examples that we often see of UCTs.
Thanks, Tim. It's really important to note, before we sort of dive into some of the, examples, it's actually really important to note that there's no one definitive kind of example of an unfair contract term. It's a very contextual assessment. So what might be, fair for one business may be unfair for another. And a lot of that does come down to whether or not that legitimate interest exists. However, there are some clauses that I guess in most common situations will likely be unfair contract terms. Now, automatic renewals or sort of evergreen clauses are a big one. These are these clauses where a contract might have a minimum term, let's say 12 months. And at the end of that 12-month period, that contract automatically renews for another 12 months and so on and so forth. And each, contract party usually has a very small window of opportunity, maybe 30 days before termination, in which they can tell the other party that they don't want the contract to renew. So it's not a case of, you sign up and then you can say the next day, oh, in 12 months' time, I don't want this to renew. It's a very small window of opportunity to actually kind of prevent that renewal from happening. And oftentimes too, there's no reminder given to either party that that renewal period has started or is approaching, and that the notice needs to be given within that period. Now, the actual fact that the contract will then renew and lock that customer or that other party into the agreement for another extended period is what's likely to be unfair. So especially too, if there are sort of, these ongoing increases and things like that, that may be buried away in the contract and weren't that transparent. In terms of how we can make these terms more fair, so things like providing notice that a renewal is coming up may increase transparency and reduce that risk that, actual detriment or likely harm is going to result. Ultimately, though, what we usually like to see is when, if the parties have agreed to a minimum commitment, say 12 months, which is fine, that's transparent, that's negotiated up front, it's not sort of, hidden away. But at the end of that 12-month period, it then goes to, say, a monthly rolling contract, or maybe, it's another 12 months, but there's still an ability for a party to terminate for convenience. Then that's something that's going to be more fair and more palatable for the ACCC and ultimately a court to look at and digest and say, well, there's an out, there's a way for a party to kind of reduce or mitigate their own losses. The other thing actually just on that as well is termination fees. So even if you give someone the ability to exit early, if your termination fees are sort of very high, or they don't sort of reflect maybe a genuine pre-estimate of loss or maybe actual losses, then it's likely that a court or the ACCC may consider them to be penalty provisions, which would be illegal and unenforceable terms. So you've got to be really mindful about, when setting those termination fees, that they're not sort of being used in a way to punish or deter instead of sort of recovering losses. Unilateral price increases are a popular one. We see them a lot in software contracts. We see them a lot in things like construction and infrastructure, where a party will want the ability to increase prices for a number of reasons. They might be just simply, it's business policy. They want pricing to increase maybe in line with inflation or to keep up with demand or increasing costs. Or sometimes it might just be that you're in an industry where materials supplies can fluctuate in costs quite frequently, or exchange rates, and you want that flexibility. Now, what we often see is more of the kind of very broad discretion, sort of an ability for a party to say, I can wake up tomorrow and change the price of this contract, and you've got to just deal with it. And that would be highly unfair. So ways in which we see that being kind of balanced to become more fair would be provisions where, maybe you still have that broad discretion, but if the customer or the other party doesn't want to or doesn't agree to that increase, that they have the right to terminate the contract without penalty, and that would override any sort of minimum commitments or extended renewal periods or anything like that, because then they're not locked into and they have that freedom to leave. The other ways we see terms like these become fairer is when they're kind of determined by pre-agreed metrics that are really transparent. So, maybe it's an annual price increase of 3%, or maybe it's, tied to the lesser of, the consumer price index, or 3%. Things where it's kind of agreed up front, there's not so much uncertainty, and there's more, parameters in which these terms operate. And again, that cancellation fee becomes relevant again as well if you are thinking about these exit pathways to make contract terms fair. And then the last example, which is always a popular one, is indemnities. Very popular in American contracts to see indemnities for everything under the sun, but also, in a lot of Australian contracts too. And really what we've got to think about is, what is the loss that we're trying to indemnify against? What are we asking the other party to give us a contractual promise to pay in respect of? Things like breach of contract, breach of warranty, breach of, or even just negligence. Those sort of very common law, very common remedies available at common law, maybe more likely to be unfair. Things that are kind of accounting for maybe third-party claims, IP infringement, data confidentiality, things like that, may be able to, justify more of a legitimate business interest. In any event, the way in which indemnity should be approached is, is it correct in scope? Is it just limited to maybe the contract parties and not sort of, I've seen indemnities where I'm indemnifying, or a client's been asked to indemnify their suppliers and subcontractors and, friends and family, all sorts of things. Things like that are going to be very broad and unfair. And is there an ability, or is there a reduction in that obligation to indemnify, or in any sort of liability, if the party looking to rely on or be protected by that clause has actually contributed to the fault or to the loss. So usually you'll see those clauses say, except to the extent XYZ is caused by, the principal or by the supplier. We want to make sure that covers, all acts and, failures to act, but also just a general failure to mitigate loss. If someone wants to rely on an indemnity, but they could have done certain things to reduce the amount of harm or cost that they suffered and they didn't, we'd want that reflected in sort of that exercise, so there's a fair allocation of responsibility. And just quickly touching on the Fujifilm case. So this was the case in where the federal court decided that, or determined that from November 2016, Fujifilm had entered into approximately 34,000 contracts, most of them being standard form. In those contracts, there are about 11 contract templates and 38 contract terms across the board that were declared to be void, unfair, and unenforceable. So this was a claim brought by the ACCC for that result. Fujifilm were ordered to cease using those contract templates, notify affected customers, and implement a compliance program and pay the ACCC's costs of $250,000. So this was a really good case for identifying the impact of, or sort of the use case of unfair contract terms and how it will play out in a court setting and what courts are looking for and what they might determine to be unfair contract terms, generally speaking. What's really important to note as well is that this case took place before the new regime kicked in. So Fujifilm actually avoided a huge risk of being fined because of those penalties weren't really introduced until the changes in November 2023. So if the case had been brought under the new regime, theoretically, if it's $50 million for each unfair term as the maximum penalty, the sort of theoretical maximum penalties that Fujifilm could have had awarded against them was around $2 billion, which is pretty significant. And that's not including, any other orders or new powers that the court may have under the new regime. So that's all the doom and gloom of unfair contract terms. I'm going to pass to Tim now to speak about some of the practical tips that you can sort of look at and take in order to kind of assess your contracts and deal with unfair contract terms.
Thanks, Stephen. Yeah, so if you do need to include an unfair term within your standard form contracts, there is potentially still scope for you to do so. And we have a few tips to, I suppose, mitigate any risk in including unfair terms within your standard form consumer contracts. So the first point is transparency of the term. So it's actually a mandatory requirement for courts to consider the extent to which a term is transparent when they're determining whether a term is fair or not. With this in mind, if you do have a term that's unfair or that may be considered unfair, you might consider adding a key clause summary at the beginning of the contract, some kind of disclosure section, or even a pop-up, before the user or consumer accepts the terms and conditions for those online contracts. This will mean ultimately the term is more likely to be considered fair. It doesn't mean that it won't be, but it does mitigate some risk in determining whether that term is fair or not. The second point is you should really determine what is a reasonable business interest and what is fair within the specific context of the contract. So a clause may be fair if it is reasonably necessary to protect the legitimate interests of the business. There is no way really to determine what is a legitimate business interest without really understanding the commercial needs and drivers of the business that you're working for or your client. So really counsel and lawyers should ascertain whether an unfair term is reasonably necessary to protect the business. As an example, if you have a client or if you yourself are entering into a contract for software development services, perhaps it may be reasonable to include, a one-sided indemnity in this case for a claim by a third party that their intellectual property has been breached. Given that, the software itself may be, a legitimate interest of your business or, the driving force of your business. The final thing is to keep in mind who the other party is within this arrangement, because what is fair to one counterparty won't always be fair for another. And then finally, you should review your internal business processes to ensure that they are safeguarded against any practical risk of UCTs. So this will include things like whether you need to update all of your contracts to account for differing counterparties, whether you need to have specific contracts that you will use for counterparties where the UCT regime will apply. But with this in mind, you should consider whether you're able to reasonably determine whether the other party is a small business or consumer, because it's not always possible when you're advising on a contract. And if you're not able to, consider creating a process for determining whether the UCT regime will apply to the counterparty. And if you're not able to set up that kind of process, then it may be best to err on the side of caution and assume that the UCT regime will apply to every contract that you're entering into. Lastly, you should also be considering your negotiation procedures. So are you legitimately negotiating and permitting changes to your terms? Or when reviewing markups, are you conscious of who the counterparty is and what their own business drivers may be? Because if not, then you may fall more likely into that standard form consumer contract category, and that UCT regime will be more likely to apply. And just wanted to touch on the New South Wales requirements regarding substantially prejudicial terms as well. So where you are supplying goods or services in New South Wales, you do need to disclose any substantially prejudicial terms, as is required by the Fair Trading Act in New South Wales. So the SPT regime applies to all consumer contracts, not just standard form contracts. And the requirement is to disclose prominently to the consumer any substantially prejudicial terms. So these terms are terms that may exclude the liability of the supplier, terms that provide the consumer that the consumer is liable for damages for delivered goods, or terms that require the consumer pay exit fees or balloon payments as examples. The requirement under the Fair Trading Act in New South Wales is that substantially prejudicial terms must be displayed via a disclosures section or a key clause summary. So with this in mind, considering often contracts are entered into with individuals from New South Wales, even if you are not based within New South Wales, it's something to keep in mind for your contracts, but it's also a useful tip for addressing the transparency requirement under the UCT regime. So with that in mind, I'll pass it back to Stephen, who will discuss some of the penalties that may apply if you do have unfair contract terms within your contracts.
Thanks, Tim. So a court may impose a financial penalty where a contract contained an unfair contract term, or where a person is attempting to rely on, apply, or try to apply or rely on an unfair contract term. Courts may also issue orders prohibiting a party from entering into further contracts containing similar unfair terms. They can also issue an order that prevents the party from applying or relying on an unfair contract term in any existing contract. So it's a very broad power that the court has. They may also just declare a contract to be void or part of that contract void and strike out that provision. So they have a lot of powers in terms of what they can do from a non-monetary perspective. I'll touch on the exact penalties shortly. Before I do that, I thought it was worth highlighting a new sort of legislative bill or sort of scheme that would be introduced to provide a designated complaints function or pathway to the ACCC for sort of certain consumer and business advocacy groups to kind of give them an ear or a dial direct into the ACCC to kind of make them aware of things that are happening in industry. These sort of complaints will need to meet certain criteria, so they have to be related to significant or systemic market issues affecting consumers or small businesses in Australia and relating to breaches of the Competition and Consumer Act, which is the legislation that the unfair contracts term regime sits within. It would require the ACCC to assess and publicly respond to that designated complaint within about 90 days, and that response must state what further action will be taken in response to the complaint. Now, there's been two good examples historically of where a sort of designated complaint pathway has worked really well in practice. So the first one is in April 2021. So this is where MegaSafe Couriers and its sole director were ordered to pay penalties. The company was ordered to pay around $2 million in penalties and the director $500,000 for partial redress. Now, this is in respect of false and misleading representations about sort of guaranteed minimum weekly payments and annual income made to their prospective franchisees. And the only reason this matter sort of arose is because franchisees complained, but there was also a referral of complaints by the Australian Small Business and Family Enterprise Ombudsman. So that sort of industry body or that organisation was able to sort of refer that complaint or bring that to the ACCC's attention for that purpose. And the other one is in May of 2021, where Telstra was ordered to pay $50 million for engaging in unconscionable conduct in relation to selling mobile phone contracts to Indigenous consumers. That particular case was brought to the ACCC's attention by various financial counselling groups and other consumer advocates. So those are two good examples of how the sort of a designated complaints function could work in practice. So if you're in an industry, I guess with, it's probably a bit early to tell what those bodies will be, but if you're in an industry where there are those sort of representative groups, it's something to just keep an eye on as that comes into play. In terms of penalties, there's two different penalties. So one for corporations and one for individuals. So for corporations, it's $50 million is the maximum penalty, or 3 times the value of the benefit obtained from that unfair contract term. But that's only if that can be determined. If that can't be determined, then what the court will look at is 30% of your adjusted turnover during the period of breach. So, in what period was that breach, or were those unfair contract terms in play? So it's a very, very high, degree of, ability there to enforce penalties for a different range of conduct, both where there's an actual sort of quantifiable harm and then when there isn't. And for individuals, the maximum penalty is now 2.5 million. I believe it was previously around half a million. So quite a significant increase. Just lastly, Tim's just going to run you through some key takeaways, and then we can get into our Q&A session of the webinar.
Thank you, Stephen. So yeah, I suppose as a next step for people to keep in mind, and really what you should be taking away from this presentation are a few points. Firstly, review your standard form consumer contracts for unfair contract terms. That's always a good starting point. From there, consider whether you need to update your contracts or whether you're able to create a secondary version for contracts where the UCT regime will apply. And within that, consider whether you're able to determine, who the other parties are and whether the UCT regime does apply, or whether you just need to be creating a standard form for all of your contracts if you're not able to determine that. As a third point, look into your negotiation procedures and consider whether you are actually engaging in legitimate negotiations with your other parties. Fourthly, get a holistic understanding of the business and really consider what are legitimate business interests that may permit you to include terms that would otherwise be considered unfair in another contract. And then finally, ensure that your client or your business understands that the importance of the UCT regime and the recent changes, noting, that this is an enforcement priority for the ACCC at the moment. And that concludes, I suppose, the main part of our webinar. And I'll just pass it on to Stephen to run through a couple of final housekeeping points.
Thanks, Tim. So I've just got on the screen at the moment our General Counsel Toolkit. It's a publication that you might find useful. It should be available, I think, in the resources tab of the Zoom webinar. But otherwise, I'll leave that QR code up for a second if you want to scan that and have access to that tool. But obviously, this will be emailed out at the end. You might be interested in our next webinar. So that is developing your in-house team through effective mentoring and coaching. That's on the 9th of July at 11 a.m. Australian Eastern Standard Time. You can also register for any of our LegalVision events by going to our website, so legalvision.com.au/events. We're going to answer your questions shortly. I'll give you a final opportunity to submit some questions. We do have a lot of them, so we'll try and get through as many as we can. So while you're doing that, I'm just going to take a few seconds to tell you about LegalVision's sort of desk extension offering. So having spoken to hundreds of C-suite and in-house counsel, we understand that lawyers, especially also in-house lawyers, are being increasingly pulled in many directions, both legal and non-legal. So that's involving you having to be providing input in business critical and strategic matters at an executive level, but also trying to manage that high volume of business as usual legal tasks. And of course, all within a tight budget. That's always seems to be the recurring theme for in-house lawyers. So under our desk extension, LegalVision can assist in-house teams with all of their business as usual legal needs, which allows you to effectively cost manage and the capability of your team by outsourcing some of your more business as usual tasks to us so that you can get stuck into some of the more business critical and strategic level matters. To learn more about how this disascension product can help you, just provide your details at the end of the survey or take up the free consultation that attendees of this webinar are eligible for. And you can speak to our enterprise team to learn more about, LegalVision, how we work, and how we can sort of benefit your in-house team or your business if you are a business joining us today. So we're going to jump to the Q&A and see how many we can get through. I've got a good question here for you, Tim, first. So this is whether an employment contract is excluded from the unfair contract terms regime.
Yeah, so the UCT regime does not apply to employment contracts. It only applies to those standard form consumer contracts that we mentioned earlier. However, it is important to keep in mind that the UCT regime does apply to contractor agreements, and there is, further scope for contractors to be disputing these claims. So it's something to keep in mind within your contractor agreements as well. Looks like we have another one as well for Stephen. If a reference document isn't available, is the contract offer complete?
Yeah, that's a good question. So, as a starting point, I would say that documents incorporated by reference. So, and what I mean by that is where a contract will say, this is subject to our standard terms online, or it might be an empty page with a hyperlink to an embedded document. But then, when we're dealing with a printout of a document, we can't actually access what that embedded document is. So these are documents that are referenced in the contract, incorporated by reference, but not actually attached or displayed in full. Now, doing that can be in and of itself an unfair contract term. We see it a lot in terms of the classic, this contract is governed by our separate terms hosted online. Naturally, because they're online, the other party can kind of amend or change those terms as and when they like. And that can make it really hard from a compliance standpoint for a contracting party to know, well, what version did I agree to, and when did I actually, agree to this change, or what's going on? So that in and of itself can be a UCT. If a document incorporated by reference is lost, or maybe it's an old version that is no longer accessible, it may just be harder to enforce the contract. It may not mean that the contract or the document sort of incorporated by reference is necessarily unenforceable. You can have sort of, I guess it would come down to a court and a judge considering, what other evidence is available to try and ascertain the scope of the obligations. The recommendation that we have is really to avoid incorporating documents by reference at all times, and just having everything, even if it does make, I guess, a level of annexures or attachments very long, just having them all in there so that there's complete transparency about what everyone's obligations are, and, better, I guess, expectation management and less likely of the dispute arising. I've got a question for Tim about the juxtaposition of the Australian consumer law. So talking about consumers not entitled to a refund for a change of mind, but, funding for talking about like a refund minus cost. Tim, think you've got some notes on that one you wanted to speak about?
Yeah, definitely. And this question comes up quite a lot with our clients as well, where, ideally an unfair term would be that you are, not, or charging some kind of cancellation fee or exit costs. And ultimately, this really depends on whether these costs are reasonably necessary in order to protect legitimate interests of the party that's trying to enforce the term. So this is more within the subscription or SaaS space. So for example, if there's a high setup cost in signing up a new customer, then a minimum term or some kind of deposit with no refund may be reasonable, but you really need to determine, for your own benefit, whether it is a legitimate business interest and reasonably necessary to include those obligations within your consumer contracts as well. Stephen, I'll pass back to you with another one. The question was, is a discretionary trust and a strata scheme considered a consumer under the ACL unfair contract term provisions?
Yeah, that's a good question. The unfair contracts regime looks to the contract. So going back to that basic principle, is it a contract for the supply of goods or services, or the sale or grant of an interest in land, so a lease or anything like that? If it is, and it's, obviously if it's standard form, then we're going to look at if one of the parties meets one of the tests. So if it's an individual, then, that would answer that. But a discretionary trust or a strata scheme is an individual, so it's not likely going to be a consumer contract for the purposes of the unfair contract terms regime. So then we'd have to look at the, small business contract definition, which is whether it has fewer than 100 employees or a turnover of less than 10 million. Now, for a discretionary trust, if it's trading, then it would be captured if it meets small business definition. If it's sort of non-trading or it's not carrying on a business, then it's unlikely. And for strata schemes, the law is less clear. So under other legislation, strata schemes are kind of afforded consumer protection. For example, in credit protection laws, they're treated as sort of, having that sort of residential purpose. But under the ACL, they would have to meet the definition of a small business. And strata schemes generally aren't carried on as an enterprise or for business, and so there's a bit of an unsettled law in the area. We'd recommend erring on the side of caution in terms of what, especially in dealing with strata schemes, erring on the side of caution in terms of contract terms, while it's sort of a bit, I guess, unclear where they might sit. Tim, there's one about price escalation, which I know we touched on in the webinar, but it's about specifically around how to manage escalating unforeseen increases in labour costs, materials and freights, for example, without being unfair.
Yeah, so this is similar to the last question, and this does come up a bit. Whether the term is unfair comes down to a few factors. One of those would be transparency. So if you can be really clear that you have these costs that are coming from third parties, then potentially you can include some kind of process or mechanism for you to increase your own prices based on increases from third parties. But something to keep in mind for any kind of price increase clause, we usually suggest having some kind of limit on what that price increase may look like. So whether it's capped at a certain amount, whether the contract price increases only once per year, or whether you are able to provide 30 days prior written notice to the consumer or to the other party, and really give them the opportunity to terminate the arrangement if they are not happy with the price variation, or alternatively refer the matter to independent dispute resolution as well. Yeah, I'll pass back to Stephen now. I think we have some live questions that we'll move on to. So
yeah, I have a question here about, and this is maybe more about consumer guarantees, but I thought it was an interesting one, just to explain sort of the difference as well. So when we talk about unfair contract terms, we're talking about obviously the use of unfair terms around the contracts themselves. And then we talk about consumer guarantees, we're talking about the basic rights that I guess consumers will have in relation to the goods or services that they acquire. Now, the question that we have here is around, and I think it may be coming up on the screen now, is around where under the consumer guarantees, when you're dealing with a B2B transaction, there's a monetary threshold of 100K. So if the contract value is over 100K, then there's no consumer law rights considerations, but the unfair contract terms regime may still apply. That's really important to know. So the unfair contract terms regime isn't dictated by the contract value, but about the party that's contracting to it. But in answer to this question, the law isn't clear on how that threshold would work for consumer guarantees in terms of services. There is case law around and I believe it was around some sort of expensive oven, where a contract was entered into for the supply of 2 ovens. Each were worth more than together were worth more than the total contract threshold for consumer guarantees. But the court looked at it and said, well, even though this is one contract worth, I think that at the time the threshold was $40,000, even though this is one contract that exceeds the threshold, they're for 2 items under the threshold, and therefore the consumer guarantees do apply. So where the upfront contract value maybe is made up of parts or isn't ascertainable, it's likely that a court would say that the consumer guarantees do apply, but it is unsettled in this area. Like when I last sort of checked in the last sort of few months. So yeah, it's best in these cases to err on the side of caution that they do apply. Tim, I think there's a question here, which I will push this one. So this is about the impact of online T's and C's that people are often required to agree to without any advice or having the opportunity to negotiate.
Okay, thanks for that. So I'll just have a quick look now. Yeah, so ultimately the UCT regime will very likely apply to these standard form online terms and conditions, given that consumers generally don't have the opportunity to review or negotiate or seek legal advice before accepting these terms. For that reason, a lot of these online terms and conditions need to ensure that they don't have any unfair terms included within them, or if you do have any terms that may be considered unfair, then what we'd be suggesting is to disclose those terms and be really transparent about any terms that may be unfair. So I think something to keep in mind, particularly if you are operating a SaaS software or any kind of online business, then it's pretty likely that the UCT regime will apply. And additionally to that, you really don't know who the other party is if they are just able to accept your terms at any time. So you really need to assume that the UCT regime will apply, and therefore, if you do have any unfair terms within your contract, then they will likely be void and you won't be able to rely or enforce them. Stephen, did you have another one that you wanted to answer?
Yes, there was a good question here around whether the unfair contract terms regime applies to government contracts. So, for example, many grant contracts are not negotiable, and government state or department state that it does not permit any amendments to the contract. This is an interesting one. So, generally speaking, the unfair contract terms regime will apply to Commonwealth and state and territory bodies if they're in the function, if they're carrying on a business. So that's where they're kind of conducting an activity which maybe has an element of trade or commerce that an individual or a general private business might undertake. Where a business is sort of, I guess, executing a statutory duty or a government function maybe set out in the legislation, that is unlikely to trigger the unfair contract terms regime, and they're unlikely to be carrying on a business. So it really depends on what that entity's core function is. If it's an entity set up or established by law for the purpose of grant funding, for example, then it may just be executing a statutory duty rather than carrying on a business. So it does depend. I'd say more times than not, government entities are simply exercising their statutory duties. And it's really just comes down to that question of are they providing sort of a commercial activity like a business would. That's a good question. I know what you mean. Those government contracts are very take it or leave it. In terms of other questions, we've got over like 40 questions. So in terms of, someone had a question here around whether terminate a contract at their own discretion, if it's fair to do so when you still have a few months left under the contract. So this one is, look, it's if your contract's very clear that either party or one party can terminate at any time without it sort of giving notice, it's only going to be unfair depending on the overall circumstances of what led to that contract being entered into. So, for example, if the contract was negotiated in after November 2023, or it wasn't negotiated with standard form, and it allowed maybe one party to terminate for their own discretion and not the other party, that could be unfair, depending on what the legitimate interest is and what the harm might be. If both parties had the right to terminate at their own discretion, and one party decides, I don't want to do this anymore, and maybe it was a fully negotiated contract, then that in and of itself won't necessarily be unfair. So it is very contextual based on the history of the contract, whether it's negotiated and who the counterparties are. Tim, I believe there was a question that you wanted to answer.
Yeah, I think there's one, I'm not sure if it's on the screen now, but the question was, can you speak further to what the threshold is for an international contract to come under the UCT regime? And is there a clear criteria? Unfortunately, there isn't a clear criteria, as is often the case with this area of law. It's quite grey. But essentially, the threshold is whether a business is carrying on business within Australia. So that might mean, and for an example, within the Ruby Princess case, they would come to Australia as part of their, I suppose, the tour, and they did have customers who would board or who would enter agreements as Australians and entering into Australian contracts. So they had an Australian contract and they had a US version of their contract. In that case, they determined that the connection was more than tenuous, and so the UCT regime did apply, but it's difficult to say with a clear answer, whether it will or won't. But consider whether there's any implication or whether your business is carrying on any kind of services within Australia, because in that case, likely the UCT regime will apply for those customers. Stephen, I think we have time for one final one.
Yeah, so there's just a question here around whether that small business contract is likely, or these UCT considerations are going to apply, likely to apply to charities and not-for-profits. So yeah, that's a good question. So in terms of, I guess, if you're a not-for-profit or a social enterprise carrying on a business, or even if you're issuing standard form contracts, you've got to remember that it's about whether one of the parties meets the conditions. So even if you might not necessarily meet the conditions, if the counterparty that you're dealing with does, then that contract is captured. If an individual is procuring maybe services for you from you under a standard form contract, or supplying services to you under a standard form contract, those considerations may still apply. And also, I believe that it's on my head, because this one is a bit nuanced when we're dealing with not-for-profits, that you can still be carrying on a business even if you're even if in the course of carrying on the business, it's actually not being carried on for profit. So that would still capture you if you're a charity, maybe with fewer than 100 employees. So that's something to be mindful of. We better wrap up now. We've slightly run over time. There was one comment about how can small and medium businesses engage, or why is engagement for legal so out of reach? Whoever that was, I highly recommend booking in the free consult. You can learn more about LegalVision's membership or your desk extension, and to have sort of unlimited consultations with lawyers and document reviews and drafting, or within sort of a fixed upfront contract price. So really recommend you take advantage of that free consultation. If we haven't answered your question as well, use the consultation to get in touch, and maybe we can go from there. Thanks for joining us. Remember to fill out the survey, and we hope you have a lovely day. Thank you.
Thank you.